we go.
Members, we're having a small technical difficulty again with just getting the amendment from the back. So as soon as we can get that, we will do this. So Senator Kathy, if you can just stand by for a second. Yeah, that's me.
Jim.
Amendments on the bill. Madam Secretary?
Amendments sent up by Senator Carter. They are set number 198. 198.
On your amendments.
Thank you, Mr. President. Members, this amendment provides, just as it did to the last bill, a child who is adjudicated pursuant to this article shall be offered educational services, vocational training, and counseling.
All right, the board has no questions on the amendments. Are there any objection to the adoption of the amendments?
Can I say something? Can I say something?
Okay, Senator Kathy for the floor.
Members, I'm not going to object to this amendment. Here's the deal, and this is the agreement that I've worked out with the author of the amendment. I want to see the fiscal impact. That's the concern that the sheriffs have to offering the vocational training that the amendment requires. If the fiscal impact is too large, through an agreement with the author, we'll strip it out in House committee. I do think that there is some merit to offering vocational training so that we don't create career criminals. And so, like I said, for that, I will accept the amendment with the understanding that if the fiscal impact is too large, we'll take it off in the House committee. That's the agreement that I've made with the author of the amendment.
Okay, Senator Carter has offered an amendment to where is there any objection? Seeing no objection, amendment is adopted. Senator Kathy,
Move final
next set,
passage.
excuse me, sorry, next set of amendments. Is it from-
Yes, yes. It's Jackson Andrews. Stop it. You know better.
Members, as we wait for another set of amendments, after this bill, we are going to break for lunch downstairs for about 45 minutes. During that time, I would like you all obviously to have lunch and then also double check any amendments you want to have for the second half of the day. So whatever amendments you want, make sure if you've emailed them, texted them, however you got them to staff, make sure you have proofread them before we gavel back in, and that means they'll be ready to go when we get in. Please, pretty please. Thank you. Senator Kathy, to close on your bill.
Ask for move final passage.
Senator Kathy has moved favorable on Senate Bill 11. When the machines are open, all those in favor vote yes, all those opposed vote no. Madam Secretary, please open the machines. Vote your machines, members. Vote your machines. Senator McMath, yes. Senator Kuson, yes. Senator Presley, yes. Vote your machines. Senator McMath is a yes. Senator Presley is a yes. Senator Kuson is a yes. Are you through voting? Madam Secretary, close the machine. 33 yeas, 4 nays, and the bill is passed. Senator Kathy moves to reconsider the vote, which the bill is passed, and lay the motion on the table without objection. Members, we will stand at recess till 1 o'clock.
And with that, we're going to close public hearing on engrossed second substitute House Bill 2065.
Thank you, Madam Chair. For those signed in not wanting to testify, there are 1,400.
24 hours of discovering the loss, loss or theft
Time and appreciate you hearing my voice today.
concerns lost and or reporting lost and stolen firearms. Under current law, if a person prohibited from possessing a firearm obtains access to a firearm through unlawful entry, the owner of the firearm must report the unauthorized access or theft to local law enforcement within 5 days of when the owner should have known that the firearm was taken. Failure to do so may result in the owner of the firearm being charged with the crime of community endangerment. If enacted, the bill, Substitute House Bill 1903, would require the owner or person in lawful possession of a firearm that is lost or stolen to report the loss or theft of the firearm to local law enforcement within 24 hours of discovering the loss, loss or theft, unless there's good cause reasons for the delay. To the extent known, the report to law enforcement must include the caliber, make, model, manufacturer, and serial number of the firearm, any other distinguishing number or identifying mark on the firearm, and the circumstances of the loss or theft, including the date, place, and manner. Law enforcement must then enter this information into the National Criminal Information Center database. And finally, the bill would make a person who fails to report the loss or theft of a firearm subject to a civil infraction up to an amount of $1,000. Thank you, and I'd be happy to answer any questions.
Thank you so much. Yes, Senator Wagner has a question, and then Senator Wilson.
So how is should have known treated in the bill? Because that's kind of a hard area for me to understand. When somebody should have known, they may have lost or had something taken from them.
Thank you for the question, Senator. The language of the bill says that the report must be made within 24 hours of when the event happened or when the owner or person in possession of the firearm should have known when that event happened, but it does not define what that term should have known means.
Senator Wilson?
Thank you, Madam Chair. So there's also good cause reasons for delay. What would be an example of good cause? Second would be why requires the make, model, serial number, distinguishing marks, all that. What if you don't have all of that?
So, Senator, to your first question, the bill does not define what a good cause reason for a delay would be. So I believe that would be a matter that would be argued in front of a court. To your second question, the bill only requires the information to be reported to the extent that it's known. So if it's not known, it would not be required.
Any other questions for staff? Seeing none, I would now like to welcome Representative Liz Berry to the Law and Justice Committee. Please do tell us about your bill.
Thank you, Madam Chair and Ranking Member Patton, for having me today. For the record, my name is Liz Berry and I represent the 36th Legislative District, which is Northwest Seattle. This is a very simple bill that's about saving lives and preventing crime. It's a common sense public safety measure that will keep our communities safer. Every year in this country, 380,000 firearms are stolen from gun owners. Only 65% of those thefts are reported to law enforcement. And the number one source of stolen guns in America is from parked cars. Here's what happens after they're stolen. Those guns are trafficked, they're sold illegally, and they're used in violent crimes. Here's the solution. This bill will require that a gun owner must report if their firearm is lost or stolen to law enforcement within 24 hours. This is before the trail gets cold, and this gives law enforcement the tools to investigate and identify patterns of gun trafficking. It will make our community safer, and we know this works because states that have these laws on the books have a 30% lower risk that guns are bought in those states and used in crimes in other states. Please support this bill, and I'm happy to answer any questions. Thank you for your consideration today.
Thank you so much. I don't see any questions for the prime sponsor. And with that, we're going to go to our panelists. We're going to have a mixture of in-person and remote. So I'm going to call 3 names at a time. If you're in person, please make your way to the front. And if you're remote, we'll start with you and ask you to unmute. So first up will be Liz Helmsath, April Schnaptrap. Sorry. We'll start with April since she's remote, and Karen Brownson. Go ahead, April.
Good morning. My name is April Schentrup. I live in the 45th Legislative District. My daughter Carmen was gunned down a week before her 17th birthday by someone who should have never had a gun. Each year, approximately 380,000 guns are stolen from gun owners in the U.S. In Washington state alone, between 2017 and 2021, there were an estimated 16,000 firearms taken from private citizens. Given the importance so many Americans place on firearm ownership, one might think that most gun owners would report a loss or theft to the police. But only 25% actually do, according to an ATF study released last year. Lost and stolen reporting laws like this one can play a crucial role in mitigating gun trafficking and upholding public safety. Research shows that just by requiring gun owners to report the loss or theft of firearms to local law enforcement, we can reduce illegal gun movement by 46%. In the U.S., 15 states already require individuals to report the loss or theft of any firearms to law enforcement. Washington needs to follow suit to keep guns out of dangerous hands. Please vote yes on House Bill 1903. Thank you.
Thank you so much. Go ahead, April. Oops, I'm sorry, Liz.
Liz, okay.
Thank you.
Okay. Hello, my name is Liz Helmsath. I'm from the 40th District in support of this legislation. Not many people in this room know what it feels like to be shot, to feel your life drain out of you because someone who should not have had access to a gun was able to do that. I know how that feels because it's happened to me, and I thank God that I survived it. As a gun owner, I know that the best way to prevent that kind of nightmare from happening to anyone else is to store my guns properly. But I know that also a criminal could still get my weapons. My first response would be to report that crime to the police because it's been drummed into my brain my whole life that outlaws should not have guns. That seems to be something that we all agree on. But apparently, some do not. It's evident that when they willfully do not report the theft of their weapons. Further, by not reporting, they are allowing their weapons to be trafficked. A lot of times we hear during these kind of hearings that this kind of law will turn a law-abiding citizen into a criminal. I don't understand that reasoning. As a law-abiding citizen, I would rather work with police to retrieve my guns than talk to police when my gun has been used by an outlaw to create a crime. As gun owners, we have a responsibility to care for and use our guns properly. That extends to reporting when they're stolen. Please let's work together to reduce this kind of crime. Thank you.
Thank you. And Carolyn, just before you get started, next online will be Aveen Klein, Anthony Mixer, and Tim Eitman. Go ahead.
Thank you. Good morning, Madam Chair and members of the committee. My name is Karen Brownson, and I'm here to give Public Health Seattle and King County's support for House Bill 1903, as part of the public health approach to firearm injury prevention. According to a 2023 report by the Federal Bureau of Alcohol, Tobacco, and Firearms, more than half of traced crime guns in Washington were linked to known purchasers but used in a crime by someone else. The median time between purchase at a licensed firearm dealer and recovery after use in a crime was over 4 years. This bill would enable law enforcement to track and recover stolen firearms faster before they resurface in incidents traumatizing our families and communities. As the manager of King County's Lock It Up program, I've closely followed lost and stolen firearms data for program planning and public education. While we know firearm theft is underreported, data give us a snapshot. For example, these data helped us understand the high prevalence of thefts of firearms unsafely stored in vehicles. We then developed messaging addressing this problem. Better data means better prevention. This bill would help prevention advocates understand the problem, give firearm owners more information about protecting theft themselves, and enable faster and better recovery of stolen guns to prevent violence and crime in our communities. Thank you.
Thank you so much. And while we wait for the in-person panelists to come up, Tim Iman, if you're on there, please unmute and begin. And I don't think he is on there, so we will move to our in-person panelists, Aveen Klein and Anthony Mixer.
Thank you. Good morning, Chair Dingra, members of the committee. Aveen Klein, State Director for the NRA in opposition to House Bill 1903. This bill won't reduce crime. In fact, this bill doesn't even address crime. It serves simply as a punishment for victims of crime and a whopping $1,000 fine for being the victim of theft. Washington voters chose to require reporting the theft of a firearm within 5 days under Initiative 1639. So why does this bill remove that incentive and replace it with the heavy hand of government and a 24-hour window? There are plenty of reasons a person may not be able to report the loss or theft of a firearm within 24 hours. That includes damage, evaluation, fear, confusion, or uncertainty of where to report. This bill would be better served to increase penalties for the actual crime of theft or prosecution for use of that firearm in a crime. Yet again, the effect of this bill will penalize the lawful gun owner and not the criminal. I urge your opposition to House Bill 1903. Thank you.
Thank you so much. Go ahead, Anthony.
Greetings, Chair Dingra, members of the committee. Anthony Mixer speaking on behalf of the Washington State Young Republicans. Our organization stands against this legislation because it is deeply flawed and needs more work. We agree that reporting lost or stolen firearms is sensible, but we have concerns about parts of the policy. First, there's no definition of loss. An unadopted House floor amendment would have helped with defining that word for the proper taking of action. It is critical to define that one word. We ask that the 24-hour period also be removed and instead changed to a reasonable time, like the next business day for some cases. Because if the victim was away from where they had knowingly secured their firearm for more than 24 hours and at no fault of their own had a criminal break into that secured device and steal that firearm, how would they know at what point in time that firearm was stolen? So members, let's not re-victimize the victim. All we ask is for these reasonable fixes. Thank you.
Thank you so much. And since Tim Iman wasn't there, we're going to see if Teo Morca is there. If you're there, please unmute and begin. Teo? Okay, we will then move on to Genevieve Willand. Oh, Teo, are
I'm
you
sorry.
there?
Yes, thank you.
Okay, go ahead.
Yep. Thank you, Honorable Chair and committee members. My name is Teo Morca, strongly opposing this bill. Guns are best kept out of dangerous hands by ensuring that those dangerous hands are not breaking into homes or cars to steal and subsequently misuse them. This is not serious legislation. This bill's only intent is to intimidate law-abiding gun owners and to continue the shift of responsibility for crimes involving guns away from prolific offenders and onto lawful gun owners. Stealing guns or providing one to a prohibited person are already illegal. The firearm community is overwhelmingly in favor of harsher penalties for stealing guns and using stolen guns in crimes because they stop repeat offenders and deter similar offenses. And because whenever criminals misuse guns, our rights are the ones that get eviscerated. Republicans have repeatedly introduced such bills, but they do not get read. In fact, some of the same lawmakers sponsoring these anti-gun bills are also pushing for reduced penalties for shootings like drive-by shootings and crimes with guns committed in school zones. Victims of home invasions may not immediately know their gun has been stolen. Imposing punishment of any kind, whether civil or criminal, on lawful gun owners whose homes and property are violated by often repeat known offenders or organized crime gangs is unacceptable. Because this bill shifts focus to the wrong party and ignores serious solutions, I strongly urge your no vote. Thank you.
Thank you. Next up will be Genevieve Wheeland, followed by Margaret Heldring and Carol Butterfield. Go ahead, Genevieve. Please do unmute and begin. Going once, going twice, and hopefully we'll see you there soon. Okay, while you are being promoted, let's go with Margaret Heldring, and we'll come back to
Yes.
Genevieve.
Yes, thank you very much. Good morning, Madam Chair and members of the committee. Thank you for this hearing. Thank you to Representative Berry for bringing this bill. I am Margaret Heldring in the 43rd District with Grandmothers Against Gun Violence. We support Senate Bill 1903. Many great comments have been made in favor of the bill so far, but let me just emphasize how this bill will prevent tragedies and harm to others. We have struggled in this country and in Washington state for the last 10 years to find a balance between rights and responsibilities around gun ownership and gun use. Congratulations to the Washington State Legislature that has done such a great job working on this. This is another tool that seeks to support that balance. The right to gun ownership is not at all addressed, but the responsibility of gun ownership is addressed. It is a cooperative gesture for a gun owner, a gun salesperson, a law enforcement person to work together to keep these guns off the streets, out of the hands of people who would do harm. So grandmothers and other gun violence prevention groups, thank you for this hearing and strongly urge passage of this bill 1903.
Thank you. Next will be Carol Butterfield.
Good morning, Madam Chairwoman and committee members. My name is Carol Butterfield. I live in Seattle. I'm the parent of 2 adult children. I am a retired Washington State nurse practitioner who worked with teens in many clinic settings. And I am also, for my sins, a 3-time PTA president, twice in Seattle area public high schools. My most recent PTA presidency was at Ingram High School, just a few years before the fatal student-on-student shooting in November of 2022. I am speaking today in support of HB 1903, which will require individuals to report when their firearm is lost or stolen. There is ample evidence that stolen guns are often used in crimes. In King County alone, a 2023 special report by KUOW stated that of the 54 open King County cases involving juveniles and guns, 20 of the guns were stolen. In the instance at Ingram High School, at the shooting there, the gun that was used was stolen. It was not safely stored, and its theft was reported 3 weeks late by its owner. Subsequently, that gun passed through at least 4 pairs of teenage hands before it was used by a 14-year-old to fatally shoot a 17-year-old Ebenezer Hiley on a school day. Ingram High School community was shattered, not to mention the greater community. The reporting of missing crucial for law enforcement to recover and return lost or stolen guns to their rightful owner. HB 1903 will also help law enforcement track the guns and disarm individuals who are in illegal possession of firearms. As a parent, healthcare worker, education supporter, and human being, I strongly urge you to vote yes on this bill. Thank you.
Thank you so much. And I think we do have Genevieve now, so please do unmute and begin. And while we wait for Genevieve, next on deck will be Jeanette McChensky, Julie Anderson, and Lori Lane. Genevieve? Good morning.
First of all, I want to show this picture of my daughter, Amy. And I am here to fully support House Bill 1903 regarding stolen guns. My 17-year-old daughter.
Genevieve, if you can move your camera a little lower, then we'll be able to see your face. But if you can't, that's fine too.
Okay, let's see.
There we go. We can see you now.
Okay.
Go ahead.
I'm here to fully support this legislation of stolen guns. And I just want to note, here we go. My 17-year-old daughter, Amy Reagan, was shot in the back of her head with a stolen gun, a .37 caliber detective special on November 20th, 1992, and died on November 21st. We buried her the day before Thanksgiving. Part of me died that day too. I sent my victim impact statement, 30 pages long, to every Washington state legislator. My heart was torn apart. She was my only child, and I loved her above everything. Every Thanksgiving, I set a place for her at the table and light a 3-day candle. When I talked to classes, I asked them when they babysit to ask the parents if there was a gun in the house, and if so, was it in a secure storage where it could not be accessed? It is an honor to be here today to emphasize how stolen guns murder and end so many lives whose contributions to society will never be known. Thank you for the opportunity to testify today about one stolen gun changes lives forever. I will work on this issue to my last dying breath.
Thank you so much. Next up is Jeanette McChensky. Please do unmute and begin, and on deck will be Julie Anderson. Okay, I don't see Jeanette, so Julie Anderson, please unmute and begin. Actually, we don't have Julie Anderson either. Lori Lane, you're up.
Hi, I can't get into my video. Can you please let me undo my video, please?
Okay, we can hear you, and yep, we can see you as well.
Okay,
Go ahead.
Yes, that's what needed to be done. Thank you very much. Hi, my name's Laurie Lane, and I'm from Buckley, Washington. And I have a question. Why penalize gun owner for a lost or stolen gun and not the criminal? At our cost. Vote no on this. Thanks.
Thank you so much. We do have 3 other people signed in to testify pro. Unfortunately, we will not be able to get to you given the time on this bill. So please do submit written testimony. And so with that, we're actually going to be closing public hearing on Substitute House Bill 1903.
Thank you, Madam Chair. For those signed in not wanting to testify, there are 1,069 pro, 1,185 con, and 2 other.
And with that, we're going to move to engross substitute House Bill 2021. We'll start with staff briefing and then hear from the prime sponsor.
And thank you, Madam Chair, committee members. Engrossed Substitute House Bill 2021 concerns the disposition of privately owned firearms in the custody of state or local entities or law enforcement agencies. Under current law, firearms are forfeited under the forfeiture and unclaimed property statutes in a manner of ways, including when the firearm was found in possession of a person prohibited from possessing firearms, when displayed or used in the violation of a written court order, or when used or displayed in the commission of a crime. Such firearms that are not ordered to be destroyed or held for evidence by the courts may be disposed of in any manner determined by the relevant legislative authority, who may then keep any proceeds from an auction or trade of the firearms. Forfeited firearms that are considered unsafe or illegal must be destroyed, and any other firearm may be retained and used by local law enforcement for a period of 1 year, after which time that firearm must be disposed of as with any other forfeited firearm. Forfeited firearms in the possession of the Washington State Patrol that are not held as evidence may be disposed of as follows. Excuse me. Illegal firearms must be destroyed. 10% of legal firearms may be retained by WSP for agency use, and all other firearms must be auctioned or traded to a licensed dealer. And firearms that are considered antiques or of particular historical value must be auctioned to a licensed dealer. If enacted, the bill would permit the State Patrol to destroy retained firearms, and the bill defines destruction as melting or shredding all parts of the firearm, including accessories. Next, the bill permits the auction or trade of antique firearms to museums and historical societies, as well as licensed dealers. And finally, the bill requires firearms acquired through a firearm buyback program to be destroyed unless the firearm is returned to the rightful owner if it's been determined to be stolen, retained for investigation or evidence, or the firearm has been provided to a museum or historical society if it's an antique. State and local entities conducting these firearm buyback programs must establish procedures for returning stolen firearms to the rightful owners. Thank you, and I'd be happy to answer any questions.
Thank you. Senator Patton has a question.
Thank you. Do we have any data from the State Patrol, other law enforcement agencies, how much money comes in that helps them when they auction off the weapons?
Senator, I'm not aware of such data, but I'd be happy to reach out to the State Patrol and find that out for you.
Any other questions for staff? Seeing none, I would now like to welcome the prime sponsor, Representative Sen, to the Law and Justice Committee. Please do tell us about your bill.
Thank you, Madam Chair, members of the committee. For the record, Tana Sen, State Representative from the 41st Legislative District. And I bring this bill forward today because I'm not comfortable with the fact that Washington State is an arms dealer. We sell guns. The Washington State Patrol currently does not have the permission to destroy weapons, and therefore they can only sell or trade them. And in fact, they have done that over many, many decades. So this legislation simply gives the Washington State Patrol the same permission that every other law enforcement agency in the state already has, and that's the ability to destroy weapons. The other aspect of the bill is to require buyback programs to destroy guns that are collected. I've been thinking a lot about the shooting in Kansas City, and just imagine if the guns were used in that crime had been given to a buyback program and yet resold. That person who brings their gun to a buyback program wants it out of circulation. They want it gone to keep themselves and their community happy and safe. And then it could be used in a subsequent crime. I don't think that's what it's about. So this legislation requires buyback programs to fully destroy all weapons. And if I might just answer Senator Patton's question, we know the Washington State Patrol has collected about $10,000 for sold weapons, and it costs about $300 to destroy weapons, or free, depending on where you are.
Thank you. Any other questions for the prime sponsor, Senator Patton?
Yes. Have you given any thought as to how many new weapons would be purchased to replace the old weapons?
That wouldn't be relevant to this legislation, I don't think, because again, a buyback program would be somebody turning over voluntarily their weapons. And again, for the State Patrol, destroying guns, they could do it when it was necessary, but not when they deemed it to not be necessary. And so it's not about taking guns out of circulation that might otherwise be used. It's about not using the guns that have been turned in and purposefully not meant to be used.
Thank you so much. And with that, we're going to move to our testifiers, starting with Dion Glover, Anne Marie Parsons, and Chief DeRoos. And I think we have Mr. Glover in person. Good morning.
Board, Madam Chair, committee members, Dion Glover for the record, Captain for your Washington State Patrol. We are in here support of House Bill 2021 today. As you heard already from staff and Representative Sen, that this does give us an opportunity to actually destroy weapons that we have seized and have been forfeitured. There's actually not very many of those, but it is tough for us when we have to sit on these weapons and our evidence storage, which costs us money. This just gives us that opportunity to destroy weapons that are no longer legal to be owned or possessed, or have an opportunity to destroy them properly. The second part of this bill also, which is really nice for us, is if the court deems that a weapon was stolen and the owner didn't know about it and the court deems us to give it back, we will search out that owner and rightfully try to give them back their legal ownership of the weapon. So we want to make sure it's very important that we noted that.
Thank you so much. Yes, Senator Wagner has a question.
Well, thank you, Madam Chair. So I understand the part about illegal weapons that come and should be destroyed. Why the legal weapons? I don't understand why there isn't a distinction for your purposes as Washington State Patrol.
You're asking why is there a legal purpose for us not to destroy legal weapons?
Yeah, I get the idea that an illegal weapon shouldn't be sold to somebody or sent out to somebody else, but why not make a distinction between illegal weapons and ones that are perfectly legal?
Well, I think actually the bill does actually allow us to do that. It gives us a distinction to do that. It's really mean the illegal weapons that we shall destroy. I think it says that firearms illegally for any person or possession must be destroyed. The illegal portion of anything forfeiture or judicially forfeited that we shall destroy. So I think it's more of an option that gives us to destroy, but if we want to trade them or sell them, we could.
Thank you. And next, we're going to go to Anne Marie Parsons. Please unmute and begin, and you'll be followed by Chief DeRoos. Please, Ms. Parsons?
Can you hear me?
Yes, we can.
Can you hear me? Okay. Thank you for the opportunity to testify today in support of House Bill 2021. My name is Anne Marie Parsons, and I'm from Bainbridge Island, Washington. Our daughter Carrie was killed in the Las Vegas 2017 mass shooting. She died by a shooter who had brought 47 weapons with him to use in this event. Our family cares a lot about the number of firearms flooding into our communities. We have learned that many confiscated guns are recirculated. They sit in warehouses, they are sold at auctions or traded to firearms dealers. Bill 2021 allows the Washington State Patrol to destroy these firearms, reducing the risk of misuse and potentially preventing further crimes. This bill would allow the Washington State Patrol the same level of flexibility as local law enforcement agencies have. It would empower them to destroy weapons and help stop the deadly life cycle of these guns. Our daughter died running from the gunshots that night, as did so many others. But let's remember our first responders too, who risked their lives running toward the shooting in these events. Out of respect for the victims and the first responders, pass this common sense safety measure. Please support Bill 2021. Thank you so much.
Thank you so much. I'll just say, Chief DeRoos, you have to accept your prompt so that you can come into the hearing room. And while we wait for the chief to accept the prompt, we're going to go to Aveen Klein, who's with us in person. And then on deck will be Teo Morka, followed by Beth Ensley and Jeanette Chensky. The other two may not be joining us yet, but go ahead, Aveen.
Thank you. Good morning again. Aveen Klein, State Director for the NRA in opposition to House Bill 2021. This bill again incorrectly focuses the blame on firearms for crime on the criminals, not their actions. Those who participate in a gun buyback program do so because they don't want possession of that firearm. Firearms sold or auctioned after a buyback are transferred in accordance with Washington's intensive firearm transfer requirements, including background checks and a 10-day waiting period. This bill is more problematic because it requires the destruction of not only the firearm and the features that make one operative, but it also requires the destruction of accessories, like a scope. What harm does an optic present to the community? This bill also requires the destruction of a suppressor, which is more complicated and more legally intensive to obtain than an actual firearm. I urge your opposition to House Bill 2021 because it's wasteful. A gun in the hands of a law-abiding citizen is no threat to the community or its safety because they are not the firearms being used in crimes. Thank you.
Thank you. And Chief DeRoos, I think we have you now, so please do unmute and begin.
Excellent. Unfortunately, I got pulled away from my desk, so I'll be testifying via the phone. My name is John DeRoos. I'm the police chief in Everett, Washington, and I'm testifying in support of House Bill 2021. This bill provides some specific language regarding local firearm buyback programs, which we've conducted in Everett since 2022. We use this program to allow community members who are in possession of firearms the ability to, especially if they don't want them in their homes, the ability to get rid of them. And they come out in great numbers for our buyback programs. In just one event, we collected 9 AK-47s, 109 long guns, 123 handguns, and all of them were subsequently demolished. The language of House Bill 2021 mandates that firearms collected through these buyback programs are destroyed in most cases. The bill further clarifies and defines what destruction means, the melting and shredding of all parts of the firearm, which make it useless. I understand that some opposed this bill want police agencies to have the ability to sell firearms collected in this manner to use towards costs within their individual agencies. While I understand very well the difficulties in managing police budgets and finding ways to fund key programs, I find the selling of firearms collected in this manner counterintuitive. While addressing gun violence in our communities cannot be solved with one approach or one House bill, there's one thing that destroying a gun that is turned in during a gun buyback program can guarantee: that it will never be used in a future act of violence or suicide. In Everett, that is a total of 543 guns so far and counting. Please vote in favor of House Bill 2021.
Senator Wilson has a question.
Thank you, Madam Chair. Chief, I was just curious, how many of those, or when you have since you've been doing the buyback program, how many of those is it required to have proof of legal ownership of that firearm before you take that in?
We do it mostly anonymously. You're talking about the people that turn them in to us?
Yes.
Yeah, we do it mostly anonymously. We do it in Everett, so we want it to be Everett community members. So sometimes we'll have them show like a utility bill, but we don't record their names. The goal, obviously, is to get the gun off the street when it's in possession of people that don't want it. So we try to eliminate as many of the barriers as we can.
Thank you. Senator Wagner has another question.
Yeah, thank you for the fine question, Senator Wilson. How do we know that the person who's turning the gun in anonymously is the proper owner? That's the question.
Yeah, we don't always know that. And we know that a lot of guns that are out there are unregistered altogether. So we're really taking the gun from the member of the community that's just in possession of it. I also know and believe, after 29 years of experience, a lot of these guns get passed around. And it's really difficult to track them in general anyway, but we do check them for stolen when we pull them in and articulate if it's stolen. We can articulate the future use of it in a criminal investigation.
Thank you so much for that. Next is Teo Morca.
Thank you, Honorable Chair and committee members. My name is Teo Morca, strongly opposing this bill. This bill is a solution in search of a problem. Our out-of-state friends at Everytown, Brady, Giffords, and so on learned that not all confiscated firearms have been taken to Mordor and melted in the fiery depths of Mount Doom and became concerned about us Washingtonians. Without a guarantee that industry-qualified firearms historians with relevant expertise and not the ATF or WSP will be the final say whether a firearm has certain cultural or historical value, there is unacceptable risk that important pieces of history will be ignorantly lost. When Larry Vickers, an American hero and former Delta operator, became sick with cancer and his special occupational tax lapsed, ATF confiscated his uniquely important collection of firearms that in some cases represented one of a kind left in the world. Did those get melted down? We don't know. When we occupied Japan after World War II, General Douglas MacArthur ordered the confiscation and melting down of swords, many being historically important, irreplaceable pieces that had been in samurai families for hundreds of years, generations. This purge was not done for public safety. This was done solely for revenge and to demoralize and humiliate the Japanese people. That is what this bill and many of these anti-gun bills this year and last are intended to do to the community of law-abiding gun owners: demoralize and humiliate. Because this bill is not about public safety and about symbolically destroying gun culture and humiliating a community, I strongly urge your no vote. Thank you.
Thank you. Beth Ensley is not with us remotely. I just want to make sure she's not here in person. Don't see anyone getting up. Jeanette McChesney, same thing, is not online, making sure she's not here in person. Okay. We'll next go to Neil Black, who will be followed by Ashley Brooks and Jennifer Dolan Waldman. Go ahead, Neil. Sorry, Councilmember Black.
Thank you. Good afternoon, Madam Chair and members of the committee. Thank you for hearing House Bill 2021. I'm Councilmember Neil Black of the City of Kirkland. On behalf of the City of Kirkland, we support 2021. The City of Kirkland has conducted 4 Guns for Gift Cards events since 2022. Our program involves the gun owners voluntarily relinquishing their handguns and rifles, and our basic procedure is pretty simple. After giving the resident a gift card and taking safety precautions with respect to the handgun or rifle, we determine whether it's stolen. If it is, we seek to return it to its rightful owner. Next, we determine whether it's been used in the commission of a crime. If it has, we retain it for evidence. Finally, if it's neither stolen nor evidence, we have it destroyed. It's very fitting that State Patrol officers have the same basic authority as Kirkland officers. I want to share a remark I shared with Kirkland's officers and the public in April 2022 when I voted to authorize Kirkland's program. None of us have to have worked in law enforcement or had a family member in law enforcement to imagine what our state patrol officers' loved ones fear most when their wife, husband, mom, or dad leave for work. We know intuitively that for many, it's concerned that their loved one will be responding to a traffic stop where guns are present. We honor law enforcement and their loved ones when we take unwanted guns off the streets and highways. The legislature should empower state patrol officers to honor their own. Thank you for hearing House Bill 2021 today and for the opportunity to comment.
Thank you so much. Do we have Ashley Brooks, either online or in person? Okay, we'll go to Jennifer Dolan Waldman. Good morning.
Good afternoon.
Oh, good afternoon.
It's a little bit after 12, yes. My name is Jennifer Dolan Waldman. I'm a resident of the 43rd Legislative District in Seattle. For several years, I have served as the chair of the Legislative Committee for the Grandmothers Against Gun Violence. Thank you for hearing my testimony today in support of engrossed House Bill 2021. Several years ago, there was a similar bill that would have allowed the Washington State Patrol, to dispose of weapons that they had taken. We supported efforts in the past, and we support them once again. No law enforcement agency composed of people charged with stopping gun violence and criminal usage should also be expected to sell guns to their citizens. This bill would allow the patrol to finally get rid of the firearms they are holding. It also specifies that destruction of a firearm means melting or shredding. I would point out that was in addition to the bill from how it was originally written. This is particularly noteworthy because in the past, taken firearms were given to companies that deconstructed the weapon and sold it for parts. The creation of ghost guns was made easier through this process, but would now be harder with the passage of this legislation. We are very grateful for the bipartisan passage of this bill in the House and are hopeful that the Senate will also support this effort. Thank you very much.
Thank you so much. Is Edward Humble here in person? Oh, excellent. Please make your way up there, and then we will have Craig Reynolds to close us out for this hearing. Go ahead, Edward.
Yes, my name is Ed Humble. I'm a resident of the 35th District here in Thurston County, currently retired. Prior to retiring, my career was in public schools as a teacher, a principal, and a school district superintendent. Then I spent over 20 years as a school district consultant for districts throughout the country. Found myself in that role. When I first started in that role, it was about school improvement and program enhancements and things we could do to improve schools. And I found it oftentimes school districts were asking us to, how do we prepare ourselves for terrible things that are happening in schools and what's going on? So I did a lot of research on that. And now that I'm retired, I've become active in those kinds of efforts. And what I found is that to prepare ourselves for those is a multifaceted puzzle. There's a lot of pieces to it. And quite frankly, as a resident of the state of Washington, I thank our legislature for filling in many of those pieces of the puzzle over the past number of years. This bill is another important piece, keeping guns from recirculating into the system. See the yellow light. There's more I could say, but keeping the guns from recirculating into the system, getting those really out of circulation is a major piece of that puzzle. And that's what my passion is. And I encourage you all to vote yes. Thank you for letting me present today.
Thank you so much. And our last testifier for today will be Craig Reynolds. Please do unmute and begin.
Good morning. My name is Craig Reynolds. I work as a consulting actuary and I'm a member of the Mercer Island City Council. I'm testifying today as a private individual and not on behalf of my employer or the city. I testify today in support of the SHB 2021, which will allow the Washington State Patrol to destroy most forfeited firearms and mandate the destruction of most guns obtained through buyback programs. We have an epidemic of gun violence in this country with more than 100 people dying from gun violence every day. And guns are the leading cause of death for people below the age of 20. This is inexcusable. No one knows how many guns are in circulation in the US, but credible estimates suggest that it may exceed the number of people living here. This is more than enough. The state has no obligation to maintain or increase this supply. Evidence for the efficacy of gun buyback programs is mixed, but we know one thing for certain. Any gun that is destroyed will not be used to kill another child. Mercer Island has had a voluntary gun turn-in program for many years, and we're in the process of implementing a buyback program. I'm proud to say that most guns we collect are and will continue to be destroyed. This is the right thing to do. The state should do this as well. Reselling collected guns effectively makes the state an arms dealer. I believe this makes us complicit in the deaths caused by these weapons. Please make it stop. Thank you for your service and for acting to protect our children.
Thank you so much. And with that, we're going to close public hearing on engrossed substitute House Bill 2021.
Thank you, Madam Chair. For those signed in not wanting to testify, there are 1,648 pro, 1,116 con, and 3 other.
And with that, we're going to move to the last bill for today, engrossed substitute House Bill 2118. We're going to start with staff briefing, and then we'll hear from the prime sponsor.
And thank you again, Madam Chair, committee members. For the record, Joe McKittrick. Engrossed substitute House Bill 2118 concerns firearm dealer licensing requirements. Current law requires firearm dealers be licensed and registered, and no dealer may sell a firearm without being licensed. The law establishes a number of requirements firearm dealers must comply with in order to maintain their license. But in the interest of time, I'd refer you to your bill report for a full detailed discussion of those requirements. But briefly, they include conditions on where a dealer may operate, the employees of a licensed dealer, and the record-keeping requirements of firearm dealers. If enacted, this bill would create additional firearm dealer licensing conditions related to employees, security, firearm storage, record keeping, insurance, and the interaction of firearm dealers with law enforcement. First, the bill requires that the employees of firearm dealers be at least 21 years old and undergo a yearly background check. Second, dealers must secure the exterior doors and windows of their business locations with security features that are designed to prevent unlawful entry, and must install a security alarm system and audio-video surveillance system that meets specified minimums. Dealers must allow access to the surveillance system pursuant to a search warrant or court order, and may allow access to the system in response to an insurance claim or as part of the civil discovery process. Third, the bill states that during business hours, dealers must store firearms in a manner that prevents access unless the firearm is being shown to a customer, repaired, or being worked on. Outside business hours, the firearm must be secured on the dealer's business premises in a locked fireproof safe or vault, in a room or building that meets the physical security requirements for the dealer's business location, or in a secured and locked area under the dealer's control while the dealer is conducting business at a temporary location. Fourth, dealers must maintain specified records related to purchases, sales, and inventory, and must maintain backups of these records either in a secured container or electronically, and must make these records of firearm dispositions available to law enforcement agencies and weapons manufacturers. Fifth, dealers must carry a general liability policy that provides at least $1 million of coverage per incident. Sixth, the bill requires dealers to promptly respond to all requests from law enforcement. Dealers must notify ATF of any loss, theft, or unlawful sale of a firearm or ammunition as soon as possible, but no later than 24 hours after the dealer should have known of the reportable event. And dealers must provide the Attorney General with an annual report of the total number of trace requests received by the dealer and whether the dealer was inspected by the ATF. Seventh, as a condition of licensing, dealers must certify in writing and under penalty of perjury that they are in compliance with all licensing requirements. And finally, the bill exempts dealers with an average sale volume of less than $1,000 per month on average for 12 months from these new license conditions created by the bill. Thank you, and I'd be happy to answer any questions.
Yes, Senator Wilson has a question.
Yes, thank you, Madam Chair. Just a quick question. So it's 2 years for the record retention, but this information is already sent to the Department of Licensing, State Patrol. But compare that to pot shops or marijuana shops, cannabis, or body police cams. Isn't this like 45 days, 60 days?
Depending on a number of factors, but I believe you're correct. I believe for body camera footage, I believe it's 60 days, and for cannabis stores, I believe it's 45 days.
And this is 2 years.
The bill requires the footage of any point of sale and a few other places inside the store be kept for 2 years, and then I believe interior views of exterior doors and windows be kept for, I believe it's 45 days.
Thank you.
Thank you. Seeing no other questions, I would now like to welcome the prime sponsor to the Law and Justice Committee. Representative Wallen, please do tell us about your bill.
Good morning, Madam Chair, members of the committee. For the record, my name is Amy Wallen, State Representative for the 48th Legislative District, Kirkland, Bellevue, Redmond, and the Boynes communities. I'll be very brief. I know you have a full agenda. Your staff did an excellent job briefing the bill. It's about keeping firearms safe, the inventory safe. It's about promptly reporting incidents, and it's about the ability of law enforcement to track straw purchases. So I think most of what's on here, honestly, is probably already done by a lot of gun dealers. We did negotiate extensively with the small business community and get to that $1,000 threshold, and as well the record retention with, I believe it's 1 year, but perhaps 2, but I believe it was 1 year in certain areas and then 45 days in others, because that was a major concern, the cost of retention. So we tried to be responsive to that, but also recognize that this is important inventory. We need cooperation with law enforcement. We need properly trained and insured businesses to be operating, and happy to take any questions. Thank you very much for hearing the bill.
Thank you so much. Senator Wagner has a question.
Oh, thank you, Madam Chair. So you mentioned that you have worked with the small business community.
Mhm.
Did you work specifically with firearms dealers?
Right.
Okay.
Yes, sir.
If you have a chance, I would love to get a list of those folks.
Yes, absolutely.
Thank you.
Thank you.
Senator Wilson?
Thank you, Madam Chair. So I guess I need to know here, gun shows, right? They last over the weekend typically. So according to the bill, this couldn't happen. So you want to completely eliminate those? Is that how
You know, that's not my understanding of the provisions of the bill, but I can get back to you about that. My understanding is just still the safe, secure storage is required on an offsite sale.
Right. I think that's the issue, because there isn't any place that would have the requirements available that are required in the bill.
I think if I were going to be having a gun show myself, I would probably cooperate with other gun dealers to ensure there was offsite storage available. But I can follow up with you on that.
Thank you so much, Rep. Wallen, for being here and for bringing us your bill. We're going to start with the first panel, Cheryl Stumbo, followed by Dr. Beth Ebel and Dr. Daniel Webster. Go ahead, Cheryl,
Yes.
please.
Madam Chair, can you hear me?
Yes, we can.
Great. Thank you, Madam Chair and the rest of the committee. My name is Cheryl Stumbo, and I'm here in support of 2118. I was shot on July 28th, 2006 at the Jewish Federation of Greater Seattle, where I worked. My shooter legally bought his gun, a 9mm Glock handgun, and ammunition from a federally licensed dealer called Hole in the Wall in the Tri-Cities, after lying on his background check form about his mental health. He was suffering from a schizoaffective and bipolar disorders. He completed the 5-day waiting period, picked up his purchases, and drove across the state to Seattle, where he forced his way into our offices downtown by holding his gun to the back of my 14-year-old niece. He shot 6 women on staff, killing 1. I personally barely survived a point-blank gunshot wound to my abdomen. I suffered through 20 surgeries over 3 years. The total cost of saving my life, which Washington taxpayers paid via workers' compensation because I was shot at work, exceeded $2 million. I can't help but wonder if the employee at the firearm dealer noticed symptoms of his mental health illness, but sold the guns to him anyway. I urge you to support 2118, which creates reasonable minimum standards for licensed gun dealers in our state.
Thank you. Thank you so much. Next is Dr. Beth Ebel.
Chair Dengra, committee members, my name is Dr. Beth Ebel. I'm a trauma pediatrician and president of the Pediatricians in Washington State, and we strongly support House Bill 2118. I'm privileged to care for seriously injured kids at Harborview, the only level 1 trauma center serving over a quarter of the U.S. But today I ask for your help. During my last shift, we admitted 5 young people under 18 with life-threatening firearm injuries. And if, God forbid, you or your family member were shot heading home, Our team would transfuse a dozen units of warm blood to save your life and rush you to surgery and do everything in our power to bring you back to your family. But I'm here because doctors and nurses, we just treat crises after they've happened, and we entreat your help to prevent gun violence in the first place. The medical professions aren't regulated, and rightly so, because you don't want just anyone hanging up a shingle and handing out medications, nor an untrained pharmacist who fails to notice or report missing pain medications. But federal oversight of firearm dealers is minimal, so that Washington communities don't have a guarantee that the dealers adhere to best practices. This bill simply requires basic measures to provide firearm safety from getting into the wrong hands, mandatory anti-theft features, standardized record keeping, and reporting timelines for lost and stolen merchandise are sensible, necessary measures to prevent straw purchases and prevent firearms from criminal use to keep our communities safe. Please join those of us who care for victims of gun violence, but we would give anything we could to prevent that gun violence. And we urge you to pass House Bill 2118.
Thank you. And while we wait for Dr. Daniel Webster to unmute, on deck will be Troy Nichols, Sheriff Mark Kreider, and Heidi Lee. Go ahead, Dr. Webster.
Thank you. My name is Daniel Webster. I'm a professor of public health policy and a distinguished scholar with the Johns Hopkins Center for Gun Violence Solution. My testimony is offered by me individually and does not represent an official position of Johns Hopkins University. A study of ATF gun trafficking investigations found that illegal or grossly negligent practices by retail firearm dealers accounted for more guns diverted into the illegal market than any other single trafficking channel. Additionally, more than 10,000 firearms were reported stolen or lost from licensed dealers, and this does not include many other firearms that go unreported when they leave the employee. Weak federal laws and resource constraints hamper ATF's ability to ensure gun dealers comply with gun laws. My research has shown that strong state and local regulation of firearm dealers with regular compliance and enforcement efforts are linked to lower rates of firearms being diverted for criminal use. Another study I led examined the effects of firearm dealers being sued by New York City for their negligent practices. When the suit was settled, we found and adopted many of the practices included in this bill were mandated. We found an 82% decrease in the probability that guns were sold by these dealers were subsequently recovered in crime. I urge you to support this bill.
Thank you so much. And with that, we're going to move to Troy Nichols. And online, we should have Sheriff Kreider and Heidi Lee.
Thank you, Madam Chair. Members of the committee, for the record, Troy Nichols here today on behalf of the National Shooting Sports Foundation, unfortunately in opposition to House Bill 2118. While we certainly appreciate the sponsor of the bill and the proponents working with us to address several of our concerns over in the other chamber, the fact remains that the cost imposed on our members by this bill, specifically the costly video retention requirements for each dealership, are significantly out of proportion with any hypothetical public safety benefits the bill seeks to gain. The stated purpose of House Bill 2118 is to prevent firearm thefts and straw purchases at dealerships. However, federal and state data clearly demonstrate that less than 2% of all firearm thefts in Washington state occur at FFLs. And given some of the earlier testimony on a previous bill, that 2% figure is probably overstated. While we're willing to accept many of the structural requirements and employee age and background check mandates in this bill, our biggest concern by far is the cost of retaining video footage as required by the bill. Even planning for the minimum number of cameras required when fully implemented, conservative estimates point to costs of more than $197,000 per year for each FFL to digitally store 2 years worth of camera footage. The proponents of the bill claim that this video footage is necessary to investigate straw purchases, but unfortunately, according to the Washington Association of Sheriffs and Police Chiefs, the number of instances reported by local law enforcement where individuals attempted to illegally purchase firearms, including straw purchases, but prosecutors chose not to prosecute the case, has grown by over 450% in the last 4 years. So all of the gun laws that are the robust network of gun laws have been passed in the last decade in Washington State aren't going to do much good if we aren't putting the bad guys in jail. So with that, Madam Chair, I'd be happy to answer any questions.
Thank you so much. Next up will be Sheriff Mark Kreider. Please do unmute and begin.
Good morning, members of the committee. My name is Mark Kreider. I'm a retired FBI agent and current sheriff of Walla Walla County. During the course of my career, I've investigated close to 1,000 bank robberies. And the only reason I mention that is in light of the video surveillance required in House Bill 2118 for FFL holders. There are absolutely no requirements for banks to have video or audio surveillance in their.
Secretary, closing machine, 33 members present and a quorum. Next bill, Madam Secretary.
Senator Kathy now moves for suspension of the rules for the purpose of taking Senate Bill 10 out of order.
Without objection.
Senate Bill 10 by Senator Kathy is an act to amend Title 15 relative to diminution of a sentence for good behavior. And Senator Kathy sends up technical amendments made at the suggestion of a legislative bureau note and moves adoption of those amendments.
Without objection.
Thank you, Mr. President. Members, Senate Bill 10 is the same bill that we passed out of this chamber in 2022 with a 36-0 vote. It simply changes the good time provision from 13 days to 13 days of good time earned for 7 days to 1 day for 30 days if you're responsible for the killing of a first responder or public safety officer. I see I have a question.
Senator Plessis for a question.
Thanks, Senator Kath. And I just, I know we had a little bit of a conversation in Jude B on this bill, and I know this has come up before. So I just want us to, because this looks like, we're moving quickly. There wasn't
Yes,
a whole
sir.
lot of debate, but ultimately what this bill is doing is that it's reducing good time.
Yes, sir.
Okay. And what is your belief on why we have good time to begin with, regardless of the crime?
Oh, like, again, as we spoke in committee on this question, you mentioned that it was an incentive to try to get people to better themselves when they come out. And I don't remember if I mentioned this in committee, but what brought this legislation was a police officer in my district that was killed. The offender got 15 years and went home after 3, and I just don't feel that that's appropriate. And so, as a to try to remedy that, this was
your response.
Yes, sir.
But this matter had been passed, but it was not signed into law.
Correct.
And how many times?
Once.
Once. Okay. Thank
Yes,
you.
sir. Yes, sir. Seeing no more questions, move final passage.
Senator Kathy moves favorable on Senate Bill 10. All those in favor vote yes. All opposed vote no. Secretary will open the machines. Vote your machine, members. Vote your machines. Senator Jackson is locked out. Senator Connick. Senator Mizell, would you like to participate? Is Senator Mizell, Senator Abraham? Senator Foyle? Senator Abraham? Senator Barrow is a no. I'm still waiting on Abraham as a yes. Through voting, Madam Secretary, will close the machine. 30 yeas, 7 nays, and the bill is passed. Senator Kathy moves to reconsider the vote, which was passed, and lay the motion table without.
Murray Mumble.
Next bill.
Bill is Senate Bill 1. Senate Bill 1.
Senator Miguez, Senate Bill 1.
Senator Miguez now moves for suspension of the rules for the purpose of taking up Senate Bill 1 out of order. Senate Bill.
Without objection.
Senate Bill 1 is an act to amend Title 14 relative to illegal carrying of weapons to provide that law-abiding persons 18 years of age and not otherwise prohibited may carry a concealed weapon lawfully without a permit.
On your bill.
Thank you, Mr. President. SB 1 provides relative to the right of law-abiding citizens to carry a concealed handgun without a permit. Louisiana has a crime problem, with 3 of our cities being ranked among the nation's most dangerous. The urgency for practical solutions has never been greater. Governor Jeff Landry has rightly identified crime as a critical issue needing immediate attention to make Louisiana safer. It's time to empower our law-abiding citizens with the means to protect themselves and their loved ones. By allowing for the concealed carrying of a firearm without a permit, we are merely offering law-abiding citizens safety to exercise their right of self-defense without a fee or other governmental barrier from a violent criminal who has no regard for the law. Criminals inherently disregard gun laws. Currently, crime is rampant, and we are offering law-abiding citizens limited options to defend themselves and their property. One of the proposed solutions to this problem is by eliminating governmental barriers to carrying a concealed firearm. This legislation will not end the concealed carry permit process. This process will remain an essential requirement for those seeking reciprocity with other states. More than half of the U.S. states, 31 to be specific, have allowed permitless open carry, just like current law in Louisiana. To be clear, it is currently legal for a law-abiding adult to open carry a handgun in public. Louisiana has long recognized this right to open carry, and it's a logical extension of this right to carry concealed with the simple act of wearing a jacket. 27 states have already allowed law-abiding citizens, individuals, to carry a concealed handgun without a government-issued permit. Those states, and most importantly, include Texas, Oklahoma, Arkansas, Mississippi, Georgia, Alabama, Florida. All the neighboring states around Louisiana give their citizens this right to carry their firearm in public. Constitutional carry does not change prohibited persons under the law or any law governing the misuse of a firearm. Prohibited places where a firearm cannot be carried or when force may be used in defense of self or others remains in place. With this, Mr. President, I'd be happy to answer any questions that the members may have, and we do have an amendment for the bill.
All right, you want to take up the amendment, get the bill in the proper posture, then we'll take some questions.
First set of amendments are by Senator Miguez. They are set number 190. Set number 190.
Thank you so much, Mr. President. What this amendment does, it'll change the effective date that's currently in the bill from April 19th to July 4th of 2024. This will give the members some time to dive into the bill. It'll also give us time to enter into the regular session and bring up some following legislation that I intend to bring up to see how this bill get members more time to look at the bill and provide additional changes before it becomes into law.
Okay, I don't see any questions on the question. I don't see any question on the amendments. Anybody have objection to the adoption of the amendment? Seeing no objection, the amendment is adopted. On the bill, question the bill, Senator Price.
Thank you, Mr. President. Good evening, Senator. How would this affect gun-free zones?
The gun-free zones that are currently in the law will remain the same.
So school system, places like that
Yeah.
have those gun-free, this will not change.
Yes, I'll direct the members to page 2, line 19, where it says, any person lawfully carrying a handgun pursuant to subsection N of this section shall be subject to the same restrictions contained in ORS 40, 1379.3 I, M, N, and O. And those are the areas under the concealed carry code as well as directing under the gun-free zones.
I didn't read the RS, whatever. Thank you.
So thank you so much for your question.
Gotcha. Senator Presley with a question on the bill.
Senator Presley.
It's good to be
look
with
great
you
up
on
here.
this side of the chamber. My question is, we've seen an expansion of constitutional carry in other southern states. Have we seen an increase in unlawful discharge or unlawful use of that firearm?
Well, in other states, we haven't seen an increase in violent crime. Obviously, in general, the biggest statistic that the FBI has always shown, and has nothing to do with constitutional carry in particular, is, we lose a lot of lives due to gun accidents or suicide. Those are the number one issues with firearms. But You and I have worked together in the House and the Senate to bring some very important legislation. Before you were here, we brought the Eddie Eagle program, which taught children stop, don't touch, run away, call an adult. Those children that are under 18 years old, to go talk to their parents to learn more if they choose to teach their children about accident prevention. Last year, Senator Morris and myself, actually the year before, brought something called the Louisiana Firearm Safety Awareness Act. And that used some of the money that state police was collecting from concealed carry permits to reinvest into public safety and provide free online training for citizens to know what the gun laws are and to know how to safely use a firearm. So I'm not sure what the other states are doing with education, but I can tell you that this legislature and this state government has been doing what it can to educate and facilitate those in the public to, through our state police and public safety, to give education out to make sure and mitigate any types of concerns that you may have in that regard.
And we're not seeing massive increases in the use of firearms in these other states, correct?
No, we're not seeing any increase in crime. Actually, in some states, they're actually seeing a decrease in crime. The Attorney General, for example, in Ohio, he recently cited, they had constitutional carry put in place last year. He cited that 6 of the 8 largest cities in Ohio saw a reduction in crime. Now, some of the states like Wyoming that have lesser crime, they don't see any change because they don't have the type of problems that we have here in Louisiana. But I think this will help, like the governor mentioned as part of his package, this will help citizens, practical, common sense solutions, defend themselves and their loved ones, exercising their God-given natural right that's been interpreted by the U.S. Supreme Court, that a right to defend themselves not only in the confines of their home, but out into the public sphere.
Thank you.
Thank you so much, Senator.
Amendments?
Amendments set up by Senator Barrow. They are set number 136.
And members, this is a simple amendment. I left my sheet in the back, but I hope I can remember the numbers. So there are 27 states that have actually passed the constitutional carry. And of those 27 states, 18 of them require that you have to be 21 in order to be able to operate that right. And so this amendment simply says, instead of being 18, an individual would have to be 21. And again, I think this is in line with some of the laws that already are in place as it relates to being able to drink. You have to be 21. I think this all falls in line. And so I simply ask for your approval of this amendment.
I see no questions on the amendment. Is there an objection to the adoption of the amendment? Senator Miguez objects. On your objection.
Thank you so much, Mr. President. So yes, Senator Barrow is correct. There were some states out there that passed constitutional carry at 21 years old. Since then, there's been a number of challenges over the last year or two that where the federal courts in, first example is the Firearm Policy Coalition against the Texas Department of Public Safety, where they had a 21-year age limit. And the court determined that the Texas statutory scheme prohibited law-abiding 18 to 20-year-olds from carrying handguns for self-defense outside the home based solely on their age. This statutory scheme violates the Second Amendment and incorporated against the states via the Fourth Amendment. They enjoined that court, and that was fully adjudicated. And then in the Eastern District of Tennessee, Beller versus Long, it was a similar court finding that the challenge scheme regulated that the possession of and carrying of handguns that restrict individuals age 18 years old and 20 years old from carrying handguns or obtaining permits to carry handguns on the basis of age alone violates the Second and the 14th Amendment to the United States Constitution. In summary, members, this amendment would put Louisiana's law unconstitutional, subject to a challenge, which would cost our state more money. We've seen another case in Minnesota where a lower federal court has found the same. It's in the appeals process, and you're seeing this across the country. I want to make sure that we pass a piece of legislation that's the best we can put in that won't be unconstitutional, and that's why I asked you to object to this amendment. Thanks so much.
Okay, Senator Barrow to close on your amendment.
Members, again, when we talk about responsibility that goes along with actually being able to carry a gun, I think it's only appropriate that we make it an age-appropriate limit, and age 21 seems to be the one. These items are in litigation, and so until the ruling is final, I think that we should actually make it 21. Thank you.
Senator Barrow's offered an amendment to which objection has been heard. When the machines is open, all those in favor of adopting the amendment will vote yes. All those opposed to the amendment will vote no. Madam Secretary will open the machines. Vote your machines, members. Vote, ma'am. Vote your machines. Senator McMath, no. Senator Allen, no. Secretary will close the machines. 27 nays, 12 yeas, and the amendment has failed to be adopted. Senator Duplessis for a, another set of amendments. Hold on.
Next set of amendments are by Senator Barrow. They are set number 169. Set number 169.
Senator Barrow on your amendments.
Members, I'm really kind of contemplating whether or not I am going to introduce it, but this is an amendment which the author and I have had a lot of conversation about in terms of individuals who actually have lost their gun rights. They were charged with a crime, and as a result of that, they lost their gun rights. And so this amendment would actually allow them to have their rights restored. But at this time, I'm going to withdraw this amendment and work with him a little bit further on it.
Senator Barrow withdraws the amendment. Next amendment, please.
Next set of amendments are by Senator Bowie. They are set number 144, 144.
Senator Bowie on your amendments.
Thank you very much, Mr. President. Members, if you would look at the amendments on your computer, there's actually four. Amendment 1 and 3 are actually technical. Amendment number 2 simply says on page 1, line 5, after permit, insert to provide relative to concealed carry of a handgun in Orleans Parish. But the essence of the amendments are in Amendment 4, which reads as follows. Notwithstanding any other provision of the law, to the contrary, no person shall conceal carry a handgun in a parish of Orleans without possessing a valid concealed handgun permit issued in accordance with RS 40-1379.3 until after April 19, 2026. Now, here's why I offered this amendment, members. Primarily for two reasons. One, implementing this amendment before there's a transition of the Orleans Parish Police Department, the city, to deal with the impact of this in two particular areas. We actually need time. This is not to say the law shouldn't be implemented in Orleans Parish, but there should be a transition for the following reasons. One, implementing it too early may in fact impact effective, responsive programs that the city has implemented. Two, it puts officers in danger in the field, and it also may impact existing laws. Now, specifically, New Orleans has implemented a number of programs since 1920 to 23 in particular. And I'll just give you a few of them because I need you to understand that to do this would really create some havoc and have a negative effect on those programs. For instance, in terms of infrastructure, the city has spent $30 million to upgrade its information system where departments can interact with each other in a more efficient and effective manner. It has invested in violence interruption and intervention programs that disrupt the cycle of violence and relationship that drives violent crime. impact of these programs. Let me just share with you what the 2024 year-to-date crime trends are in Orleans Parish. And what you heard when our governor gave his opening address was our citizens who had been victimized between those years these programs were implemented as a result of that. But here are the trends for 2024 since these programs have been implemented. Auto theft, down by 32%, burglary down by 23%, carjacking down by 28%, homicides down by 22%, non-fatal shootings down by 44%, rape down by 36%, armed robbery down by 45%, stabbings down by 30%, and vehicular burglary down by 37%. That is extremely important in terms of the direction that the city is going relative to the programs it has implemented and those laws that are now being done to deal with our issue of crime. Now, what's to we have the Super Bowl coming in 2025. These officers in the city need an opportunity to work how this will be an impact on those individuals who will now be able to carry without a permit, not just the residents, but those who will be coming to the city. It is critical that we have the opportunity for this transition. And so, members, I simply ask you to allow this amendment to pass, to allow us to continue the trend that I just read to you in terms of how we are impacting crime, to give our state troopers, the Orleans Parish Police, and our city the opportunity to figure this out. Let me share with you specifically how it also may impact existing laws. In 2023, the New Orleans Police Department confiscated 2,768 illegally possessed firearms. And the way they were able to do that was because of something called reasonable suspicion. That is, it allowed our officers who suspected an illegal carry to actually stop and frisk that individual. If our officers, state troopers, don't have time to analyze the impact of the constitutional carry and its impact on that piece, then we may have some serious problems. We may have to get rid of that particular tool altogether, but they need time to analyze it. The other thing is that when in fact the constitutional carry becomes law, one of the things that the Fraternal of Police have said is that the officers will be put in some very precarious positions because they would have to spontaneously make a decision about how to deal with this situation. And it may cause some undesirable use of force situations. So across the board, there may be a need of time. And I was glad to hear Senator Miguez say he was changing the date to July. But in the case of Orleans Parish, we need a little longer transition. And all I'm asking for is for this to actually happen after the 2020, or it happened in 2026, only 2 years after it becomes law. State police, Orleans Parish Police, and the city will have enough time to actually look at those things I've told you here. So I'm asking you to consider that for New Orleans as a special urban center in our state so that we can respond accordingly to this new law. Thank you very much. I see no questions, and I ask for your final approval.
Senator Bowie has offered up an amendment to where Senator Miguez has objected. On your objection?
Thank you, Mr. President. If you members, if y'all remember, we worked very vigorously over the last term on the preemption laws. And basically what that does is we worked hard to make sure that we don't make law-abiding citizens across this state in Shreveport, Lafayette, Lake Charles, Baton Rouge, a criminal because they don't understand what the local gun laws are in New Orleans. We worked hard to make sure we have a consistent set of gun laws that are dictated on the state level. And Senator Bowie, I appreciate some of your concerns. We're going to be in the regular session. We're going to have some time because I moved the effective date back to July 4th. It also talks about negligently carrying a firearm, same restrictions in the constitutional carry that are in the concealed carry code. If it's criminally negligent, a criminally negligent manner as defined under this provision of this section, or is negligent in carrying of a concealed handgun, the law enforcement officer may seize the handgun into adjudication by a judge. This is all covered currently in this bill. Another thing that the section of the code that deals with concealed carry covers is it is currently illegal to possess a firearm at a government permitted parade. So all the Mardi Gras parades that are going on, it's illegal to possess a firearm. So if a law enforcement officer under the current law have reason to believe that a patron of the Mardi Gras parade was a suspicion of using drugs or alcohol, was negligently having a firearm, and they saw him printing, they could go up there and stop that individual and ask for his ID, for them to identify himself, and then he can determine whether he's a law-abiding citizen or not, and they still have the same rights. So with those, members, I ask that you reject this amendment, and I look forward to furthering the conversation. Reject this amendment, and I look forward to furthering the conversation in the regular session about different aspects of the bill.
Senator Bowie, to close on your amendment.
Thank you, Mr. President. And thank you, Senator Miguez, for addressing those issues about constitutional carry. However, I just read you the present 24 trend for those programs that have been implemented. Turnaround for 2024. I can clearly tell you if this law is implemented prior to that transition happening in the city of New Orleans, you will see all of those numbers go back through the roof. I'm not asking you to exempt Orleans Parish. I'm saying allow our state troopers and our Orleans Parish police and the city to make this transition. We are a unique city. We're not like no other urban center in Louisiana or in this nation. And so this should not be a blanket, or we're going to implement it everywhere. If we're saying we're committed to reducing crime, then I'm offering you some facts about this urban city that is our economic engine, and we Troop NOLA that the state is sending will need this to do this. And so I'm asking you, just because we can implement it tomorrow, please don't, because that is not a responsible way to do this. I ask you to consider supporting this amendment. Thank you.
Senator Bowie has offered an amendment to which I was objection. When the machines are open, all those in favor of the adoption of the amendment will vote yes. All those opposed will vote no. Secretary, open the machine. Vote your machine, members. Vote your machine. Secretary will close the machine. 29 yeas, 10 yeas, and the amendment has failed to adopt. Next amendment.
Next set of amendments are by Senator Talbot. They are set number one.
Withdraws.
Next set of amendments are by Senator Carter. They are set number 170, set number 170.
Thank you, Mr. President, members. What this amendment does, it acknowledges that we really have a gun problem in Louisiana. And so what this legislation provides that if Senator Miguez's bill on constitutional carry were to become law, the following individuals will not be allowed to conceal carry. Can you hear me? No. It's not.
Just refresh your computers.
What this amendment provides is if Senator Miguez's concealed carry bill becomes law, the following persons shall not be allowed to conceal carry in the state of Louisiana. And there's three categories of individuals. One, any person prohibited from lawfully purchasing a weapon. Two, any person prohibited from possessing a weapon under Louisiana law. And then three, and this is the most important one, any person that is subject to a court order pursuant to this amendment. And what this amendment provides are red flag opportunities for our district attorney. If a district attorney or an assistant district attorney receives evidence that a person is a danger to themselves or others, that district attorney can petition a court for an order where that person is not allowed to conceal carry in the state of Louisiana. If the court issues such an order, there has to be a hearing within 14 days. The state, the district attorney, will bear the burden of proof for clear and convincing evidence that the person, whether or not the person is in fact a danger to themselves or others. Some of the factors for the courts to consider in terms of whether or not someone is a danger to others is evidence. Affidavits submitted by the district attorney that that person is in fact a danger to themselves or others, whether or not there were any past threats of acts of violence, whether or not there were any threats of suicide or threats against someone else, whether or not there's been any reckless use or display or brandishing of firearms, whether or not that person has a history of use or attempted use or threatened physical violence against any person or against themselves. We heard Senator Miguez talk very briefly about the suicidal concerns. There are many concerns with people who should not have weapons because they're a danger to themselves or others. This gives our district attorneys a remedy, the possibility to go to a court, present evidence as defined by this statute, along with constitutional due process protections, to allow a court to issue an order and say, this person shall not be able to carry or possess a weapon. And I gladly answer any questions that you may have. I've spoken to Senator Miguez about this amendment. We've actually debated this bill when we were on the House side, the red flags legislation many, many years ago. It's actually how we became friends. In the course of this conversation, he told me that he's not open to any amendments, good or bad, during this session. I assured him that this was a good amendment. Many states have offered red flags legislation intended to stop mass shootings, intended to stop school shootings, intended to stop suicides, intended to stop gun violence in general. There are so many people who should not have access to guns. This gives an opportunity for our district attorneys to pursue such an order from the court. I see a question.
Senator Luna for a question on the amendment.
Thank you, Mr. President. So as I understand it, this would make it where the bill would not apply to someone who cannot lawfully purchase a weapon?
That is correct.
So if you came to me and said, I have a conviction, or I've been under a PEC or whatever it is, here's some money, go buy this gun for me in your name, then it would not apply to you in that situation where you could carry it.
That's
Is that
right.
correct?
Yeah.
All right, thank you.
And not only that, but they will also prohibit those people who display red flags from also concealing, from carrying a weapon openly or concealed.
The board is clear. Senator Carter has offered an amendment, so there's objection. Senator Miguez, on your objection.
Thank you, Mr. President. As I'm looking through this amendment, in the first part, which is first substance section, looks to be around amendment number 6, and it's completely unnecessary because we worked very hard in this bill and addressed a lot of these issues. If you look at page 1, when it talks about the eligibility of those who can carry a concealed, Constitution concealed handgun, if you look to M2, it says someone who is not prohibited from possessing a firearm under RS 1495.1, 18 U.S.G. C, 922G, or any other state or federal law. So if you just grab one of the laws randomly, the 922G, and you look through it, it talks about possession of a firearm. It talks about those who are felons who can't possess a firearm, those who are fugitives from justice can't possess a firearm, under dangerous controlled substances. If you're an illegal immigrant or you're here illegally in the United States, you can't possess a firearm, which means that you can't possess it constitutionally. And then you kind of get into it a little bit more, and it talks about court orders. So if you currently have a court order, either through state law and the judge says you can't possess one, then you don't qualify for my bill. But if you are restrained from such person from harassing, stalking, threatening an intimate dating partner or a child, or you have threatened intimate dating partner or a child from seriously bodily injury, I mean, this is all covered under federal law. You don't have the right to possess. So when you don't have the right to possess, it triggers the restrictions inside of my bill. So so a lot of his additions are unnecessary. It's already covered in the bill currently. Then you get into the next set of amendments, number 7, and it's about a few pages long and you have to read it. If Senator Carter wants to debate red flag laws, we will have the opportunity to in the regular session coming up. This bill is about constitutional carry. We worked very hard to make sure that this bill stayed in line. It didn't change a lot of the places that are prohibited now from carrying a firearm, and didn't add more places where you could carry a firearm. We kept it in line with the current law. So as we go, we just extended the effective date to July 4th of 2024. As we go into the regular session, we're going to have those discussions. That will be an opportunity for Senator Carter to bring that bill. We can put more time into it and we can fully vet it. And I got some other ideas that I want to run by him on strengthening citizen Second Amendment rights. I just don't think this is the appropriate time because we put so much work into the bill, and for that is the reason why I object.
To close, there's no questions to close on your amendment?
Senator Miguez is right. His legislation does provide that people who are currently, according to federal statute, from possessing a weapon shall be excluded from his concealed carry bill. I acknowledge that. We discussed that. What this bill does is not only does it make certain in plain language, not just a cite to federal law, that those persons who can't lawfully possess a weapon can't conceal a weapon. It also expands it to, if you currently cannot purchase a weapon, you can't conceal carry in the state of Louisiana under any circumstance. Separately, regarding the red flags, we should not wait on that. We should not wait a moment on that. 2 years ago, we heard a red flags law in Senate committee. It didn't get out of committee. Less than 2 weeks later, the Uvalde school shooting happened. A school shooting can happen at any given point in time. And when we find out as parents that there's been a shooting at our kids' schools, it doesn't matter if you're a Democrat, you're a Republican, if you're from New Orleans, or if you're from Tensall Parish. At that moment, you're a parent. We have a gun problem here. The substantive part of this amendment is the red flags provision. There are some people who are a danger to themselves or others who should not be able to possess a weapon. This empowers our district attorneys to petition a district court, present evidence to meet a standard of clear and convincing evidence. That's a high standard to my non-lawyers. And if that court issues that order with all the constitutional protections that we have outlined in this bill, yes, that person shall not be allowed to carry or otherwise possess a weapon. I ask for your favorable passage. We will have legislation on this during the regular session, but we have Senate Bill 14 that's also going to be heard in Judiciary C next week. And during that committee hearing, and I ask all of you to listen, you're going to hear the empirical data behind the red flags laws. You're going to hear the number of red states that have adopted these laws and the tragedies that these sorts of laws can prevent. There's no reason to delay. This is a good amendment. It's well thought out, and I ask for your favorable passage.
Member Senator Carter has offered amendments to which has been objection has been heard. When the machines are open, all those in favor of adoption of the amendment will vote yes. All opposed to adoption of the amendment will vote no. Madam Secretary, please open the machines. Vote your machines. Senator Barrow, yes. Senator Kusan, no. Senator McMath, no. Madam Secretary, we'll close the machine. 28 nays, 11 yeas, and the amendments failed to be adopted. Any more amendments? No more amendments. Senator Duplessis for a question on the bill. Senator Miguez, if you'd like to join him at the mic, that would go a long way.
Thank you, Senator Miguez. I just had some clarifying questions on the implementation and how this will apply. I know you addressed earlier the gun-free zone component of it. I just want to be clear, does this apply, does that same concept apply to public facilities like Superdome, Convention Center, this building that we're standing in right now?
Yes, but it's between two different sections of state law. But it considers the Capitol building, it considers certain public and governmental buildings, and also.
So it would not apply? The same?
Yeah, it would. It's wherever the law is currently, it's the same in this bill when we reference all those different sections.
Okay, thank you. Age, why did you select 18?
I had mentioned it earlier when I think it was Senator Barrow came up with an amendment. We talked about the group of individuals between the age of 18 prior to 21 in Texas. And then what was the other state I mentioned? It was Tennessee and also Minnesota. In Texas and Tennessee, that's been fully adjudicated and appealed. The courts found that it was in violation of the 14th and the Second Amendment, and they enjoined those state departments from basically not allowing those individuals to have constitutional carry rights. This was after the 21 constitutional carry laws in those states. And then in Minnesota, a lower court said the same is currently being up on appeal. So we're seeing this get overturned in every state.
But that was the question. I believe her question was, I think she was trying to do 21, and there was a lawsuit you referred to 18 instead of 21. My question is, why 18? Why not 17?
Well, because the age of majority is 18 years old. I mean,
So you can be 18 to carry a weapon concealed without a permit, but you can go to adult prison. What's the difference in the two? I'm just trying to understand from an adult competency standpoint.
You could, I guess you could technically open carry or as a 17 or maybe 16-year-old. I think one part is you have to have
your bill says 18.
Yeah, because it's concealed carry, and we're trying to follow in line with other states. And you're
so there is a difference between 17-year-olds and 18-year-olds.
You and a few other members were concerned about crime trends. And we have data that shows that 18-year-olds carrying a concealed firearm have no effect on increasing crime when they're doing constitutional carry. If we go to 17, we might enter a new realm. And if that's something you want to talk about, lowering this bill to 17 years old, we can have that discussion. But I don't know if I'm going to provide the statistical data to back up the safeguards.
But there appears to be an acknowledgement between a difference between 17 and 18-year-olds. Would you disagree with that?
There's been an expression across the nation that 18 is the age of majority. If you're an attorney, you're very well aware that when you're 18, you get capacity, you can sign a contract, you can borrow money, they can ship you off to war. You can do a number of things at 18 years old. So it's kind of a common known deal outside of smoking and alcohol, which that's a different discussion altogether. 18 is pretty much the age of majority.
Right, but we decided we're not going to apply that. But anyway, let me move on from that. Final question that I have for you is, does law enforcement support this bill?
Law enforcement, and that's a broad term. Are you want to be more specific?
Well, we use it quite often in this building. So I'm asking law enforcement, DAs, sheriffs, fraternal orders of police, do they
Okay,
support this bill?
Let me go through my best recollection of where they are because some testified and some of this is, is information that was provided to me. And I apologize to any law enforcement agency if I'm misstating your position. Please, after I make my statements, please let me know so I can make sure that it's recorded on the record properly. But the state police are not opposed to this legislation.
Do they support
The
it?
sheriff's association are not opposed to this legislation. The chiefs of police are not opposed to this legislation.
Okay, but
The
my
fo-
question
the
was,
New
does anyone
Orleans
support it?
Hang tight.
Does
The New
anyone
Orleans
support it?
Police Department is opposed to this legislation, and the Fraternal Order of Police are opposed to this legislation. Your next question is going to ask me, do they support it?
No, my
And-
only question is, that's my only question. Does anyone support it?
And the reason why they don't support it as a group is because, I know because I have some friends who are chiefs of police and sheriffs, because they found that there's a split between different sheriffs. I mean, the last time this bill came through in 2021, I think Senator Sabine Sheriff, and I think the sheriff up in Bossier Parish wrote an op-ed in support of this legislation, thought it was the best idea ever. And then the sheriff down in, I believe it was either Terrebonne or Lafourche Parish, took the opposite position. So the sheriffs are actually split on this. You have some sheriffs that support it, some don't. And I think they have to, when they have to combine their voice as an association and an expression, they can't come to a position. So they've taken a no position on the bill, which means it's a split, a mixed bag with them.
Thank you.
Senator Talbot for a question on the bill.
Thank you, Mr. President. And I think I know the answer to this, but I just want to make sure I understand this right. So you amended the bill to go into effect July 1st, right?
4th.
July 4th. So, and I had an amendment that, Bourbon Street is, like Dr. Bowie said, New Orleans is a unique city, but Bourbon Street is an extremely unique area. It's basically a 12 or 14 block outdoor bar, which currently you can have a concealed weapons permit on that street. What I wanted to do with my amendment was just to keep it that way and not have, constitutional carry on Bourbon Street. But you'll work with me in the regular session. I know you just don't want to address gun-free zones here, and
yeah,
we'll just do that in the
And I
regular session.
haven't stated my official position on that just
know
yet,
that.
but
I know
we'll
that.
have that debate. And just to get you thinking, and for
Okay.
the members, when we're going to have those discussions, we're going to look at the current code and see where we're already restricted. So under concealed carry law, which is also the same here because I'm attaching the two with the reference in the bill. We mentioned it before. You can't carry a firearm at a Mardi Gras parade. You also can't carry a firearm inside of a bar. For this particular circumstances, Bourbon Street, you can't be under the
Well,
influence
Bourbon
of
Street you can. Bourbon Street is not,
inside of a bar because
Right, but
it's restricted. in
Bourbon Street itself is just one big outdoor bar, but we can debate that
inside of a
later.
bar. So
Right.
we have some restrictions in place. So I think the part that you're talking about is Bourbon Street itself. That's the actual public space. And then we'll have to look at it and consider the
Yeah, I'll work with you on that.
constitutional
I just,
consequences of that.
people had,
But I
saw the
don't
amendment.
necessarily say I support that
I
just yet.
understand, right, because you haven't seen the language yet. I just wanted to make people aware of what I was doing. I filed the amendment, then I withdrew it, and people were kind of calling me saying, hey, what's going on? So, well, I appreciate you, and we'll talk about it in the
Thank you
spring.
so much. Look forward to it.
Senator Duplessis on the floor for the bill.
Thank you, Mr. President. Members, it's important that I just come up here and express to you why I believe this is by far one of the most dangerous pieces of legislation that's about to pass out of this building, and I strongly oppose it. We are here to address the issue of crime. We are here to address the issue of public safety. There is not an ounce of data or evidence or common sense that suggests that this bill will make our community safer. I want to thank everyone who tried to offer an amendment to make the bill better. Unfortunately, none of them were offered, but I want to read to you all, and please just bear with me. I want to read to you all a letter that I received. I don't know if you all received it. Typically, we get floor notes in support or in opposition. So I asked Senator Miguez, where was law enforcement on this issue? He said he doesn't know. They're divided. Some are for it, some are against it. Well, let me tell you what I know about what law enforcement sent to me. This is from the Louisiana Fraternal Order of Police. And I ask any members of law enforcement who support this to please contact me. Let me know. This is what the letter says. It was written to the mayor of New Orleans. Dear Mayor LaToya Cantrell, I am writing you on behalf of the Fraternal Order of Police to express our deep concern regarding the proposed legislation to implement permitless concealed carry in our state. As the president of FOP, representing law enforcement officers across Louisiana, I feel very compelled by the serious reservations of our organization has about this proposed measure. Permitless concealed carry undermines the safety of both law enforcement officers and the general public. By eliminating the requirement for individuals to obtain a permit, we are effectively removing a crucial layer of accountability and screening that helps prevent firearms from falling into the wrong hands. Permitting processes ensure that individuals seeking to carry concealed firearms undergo background checks, receive training, and demonstrate a basic understanding of firearm safety laws. Removing those safeguards increases the likelihood of firearms ending up in the possession of individuals who may pose a danger to themselves or others. Moreover, permitless carry creates significant challenges for law enforcement officers in the field. I'm gonna say that again. Permitless concealed carry creates significant challenges for law enforcement in the field. Without the ability to quickly and easily verify whether an individual is carrying a firearm legally, officers are placed in potentially volatile situations where they must make split-second decisions with limited information. This not only heightens the risk of confrontations, escalating into violence, but also increases the likelihood of tragic misunderstandings that could result in a critical use of force issue. I'm almost done. Furthermore, permitless concealed carry undermines the ability for law enforcement agencies to effectively enforce existing firearm laws and regulations. Without a clear mechanism for tracking and regulating the carrying of concealed firearms, it becomes increasingly difficult for officers to identify and address illegal firearm activities. This hampers our efforts to combat gun-related crime and ensure public safety. In light of these concerns, we urge you to oppose permitless concealed carry legislation. Instead, we encourage you to prioritize measures that enhance public safety and support law enforcement efforts to keep our communities safe. Now, this is from the president of the Louisiana Fraternal Order of Police. If this man doesn't represent law enforcement, I don't know who does. But we don't seem to want to address that. We talk about law enforcement all the time and how much we support law enforcement. We just passed the bill before this one that reduced the amount of good time you get if you kill a law enforcement officer, a peace officer. So on one hand, we care about law enforcement, but here it is, they're telling us they don't want us to pass this legislation, and we're just going to do it anyway, because in Senator Miguez's words, this is our God-given right. Well, I never saw that in the Second Amendment, nor did I see it in the Supreme Court's interpretation of the Second Amendment. But I did read the First Amendment, which said that this state, both state and national, federal law, says that we shall not honor or establish any right of religion. So my God does not say that everybody gets to carry a gun. So your right to carry a gun should not infringe on my right or my family's right to live safely in a community. And that's what this bill is going to do. It's going to make us less safe. Thank you.
Senator Morris for the floor on the bill.
Thank you, Mr. President. I will be brief. The Fraternal Order of Police is a union, it's a labor union, and it doesn't represent all of law enforcement. And I'm going to read what my police chief, who recently retired, Jeff Terrell of the city of West Monroe, said, and it's very brief and it gets to the point better than I could. Quote, based on my reading of the Constitution, it says, you can keep and bear arms. The founders made it clear. Restrictions don't hurt anyone but law-abiding citizens. When you look at it,
The people that are not going to follow the law are criminals. They're going to carry whether the law says they can or cannot, close quote. I urge passing this bill.
Board is clear. Senator Miguez, your right to close on your bill.
Thank you so much. I'll take you back for a moment to 2008 to the Heller case, where Justice Scalia wrote, "The Second Amendment protects an individual right to possess a firearm unconnected with military service in a militia and to use that arm for traditional lawful purposes, such as self-defense within the home." The Brewing case just most recently extended that into the public sphere. States that have enacted constitutional carry have not divulged into the Wild Wild West. And I'll give you some statistics on a few states that have done it. After Alaska adopted constitutional carry in 2003, there was no spike in the number of murders, including those committed with guns and with handguns explicitly. After Arizona adopted constitutional carry in 2010, there was no increase in the number of murders, including those committed with guns, including handguns explicitly. Wyoming has historically had few murders, and the trend continued after constitutional carry took effect in 2011. Firearm-involved murders in Idaho have not spiked after constitutional carry. Here's one of our neighboring states. Arkansas enacted constitutional carry in October of 2018 and saw fewer homicides committed with handguns in 2019 and 2020. And most importantly, in the most recent statistic, as reported by the Attorney General of Ohio earlier this year, 6 of Ohio's 8 largest cities saw less crime after the state's constitutional carry law took effect, according to a study published by the Center for Justice Research. This legislation is about making Louisiana a safer place to live. Since criminals already carry concealed firearms without regard for the law, constitutional carry simply puts law-abiding citizens on equal footing. Constitutional carry gives criminals a reason to fear any potential victim who could be armed and disincentivizes criminal conduct. Because we all know that only thing that stops a bad guy with a gun is a good guy with a gun. The time for action is now. Let's empower law-abiding citizens with the means to protect themselves. The Second Amendment is our God-given right to bear arms and defend our families. No more begging the government for permission to protect what's ours. This is about our freedom, our way of life, and our safety. Members, I ask for your favorable passage.
Senator Miguez moves final passage of Senate Bill 1. When the machines are open, all those in favor vote yea, all those opposed vote nay. Madam Secretary, please open the machines. Vote your machines. Senator McMath, yes. Senator Kuson, yes. Senator Reese, yes. Secretary, close the machine. 28 yeas, 10 nays, and the bill is passed. Open the bill for Senator Miguez request. We open the bill for co-authors. The machine, excuse me. Secretary, open the machines, please. The co-authors. Senator Kuson, yes. Secretary will close the machine. 23 co-authors. Next bill.
Senator Miguez now moves for suspension of the rules for the purpose of taking Senate Bill 2 out of order.
Senator Miguez on Senate Bill 2.
Senate Bill 2 is an act to amend Title IX relative to liability of persons authorized to carry a concealed handgun to provide with respect to persons authorized to own, possess, use, or carry a concealed handgun.
Senator Miguez on your bill.
Thank you, Mr. President. SB 2 provides a limitation of liability for persons authorized to carry a concealed handgun pursuant to a permit or a post-certification. The intent of SB 2 is to incentivize individuals to practice safe gun ownership and usage. This legislation will also protect responsible gun owners from frivolous lawsuits. While Louisiana has the basic common law doctrine of self-defense immunity, under current law, an individual who uses force in self-defense is still forced to be dragged through the civil litigation process and through a trial to prove that their actions were a justifiable self-defense. Indeed, there have been cases in Louisiana where individual acted in justifiable self-defense has been forced to incur substantial legal costs simply to prove that their use of force was justified. This bill, SB 2, complements the bill that was just passed, SB 1, constitutional carry, that I'm offering this special session. While I do not believe that the government should mandate additional requirements for law-abiding citizens to exercise their constitutional rights to bear arms, I do believe in incentivizing citizens to get the proper education and the training regarding the responsible exercise of their Second Amendment rights. Government's role should be to educate and facilitate this type of safety training required to obtain a concealed carry permit or a law enforcement post-certification. This proposed legislation seeks to incentivize citizens to go through the proper education and the necessary training to get their concealed carry permit or to become a personal
Last thing we want to do is have a person who has a concealed carry permit acting recklessly, and because he has that permit, he thinks he can shoot indiscriminately into a crowd. If he's shooting after, someone who's committed a crime. We don't want innocent victims to become no right to recovery. If the concealed carrier is acting irrational and even doing a situation where he has the right to use his gun, he's got to carry that gun in a proper way. And that's all this amendment does. It protects innocent victims. And I think there's no objection to the amendment, but I'm here to answer any questions. I see no questions.
Board is clear. Senator Connick has an amendment. Are there any objections? Seeing no objections, the amendment has been adopted. Next amendment.
Next amendment is by Senator Morris. They are set number.
He waives.
He waives.
Next amendment.
No further amendment.
No further amendments. Board is clear. Senator Miguez, to close on your bill. Senator Miguez, to close on your bill.
Thank you, Mr. President.
Sorry, you did not close fast enough. Senator Bowie for a question.
Thank you, Jay.
Thank you, Mr. President. Senator Miguez, in presenting your bill, you said that the bill will incentivize individuals to register to get a permit. Do you have any data that say that in fact, and you said there was out there and you would have some for me. Do you have the data now that says the extent to which individuals will be incentivized to go and pay for a permit to carry when in fact they can carry without that constitutional carry?
Well, I'm trying to find the study. I have it. I'll give you the summary of it. We looked at, you had asked another question. Look at if that, in that case, when you had constitutional carry, if it reduced the amount of concealed carry permit holders who applied for it, because you had some fiscal concerns at the time. So there was a study out there, and I'm gonna have to dig through my paperwork to find it. I can provide it to you a little bit later. That shows that nationwide, there hasn't, in each particular state, there hasn't really been a reduction in the amount of concealed carry permits that were applied for. And when they looked at it holistically, it was only about 0.5%. And that was of the whole nation, which had millions of concealed carry permit holders. So in summary, when states put in constitutional carry, the individuals still go and get their concealed carry permit rights. Now, you might ask yourself, why is that the case? Well, it's because there are two benefits, and I only mentioned one in committee. I thought of a second one, and I appreciate you getting my thought process going on that. The first is reciprocity. So if you have a concealed carry permit in the state of Louisiana, you get reciprocity with those states who are in agreement with us, which means you have concealed carry rights in other states. The second is when you go to purchase a firearm, if you have a concealed carry permit, it also means you have the background checks and you've been checked out by state police. So you're able to go through a much quicker process to purchase your firearm. So that's just common sense, right? If you give incentives, people will do something. Well, what this bill does, it gives a third incentive. The third incentive in this bill says that if you have to unfortunately use that firearm in a self-defense scenario, the bad guy who's trying to threaten your life or threaten the life of your loved ones, and you use your firearm, he can't drag you, he or his family, his heirs can't drag you through court, sue you, where you have tons of legal costs.
Can we still
So
focus on
if
my
you have
question?
three incentives, so in other states, they've had two incentives, and we saw no reduction in concealed carry permits, and I'm adding this new incentive, I can tell you that it's either going to be equal or greater, which would be more money to state police's budget.
So your answer to my question is that there's no increase, no data that shows an increase in incentives, but there was no decrease.
There was no decrease.
That was the answer to my
Under the
question.
current incentives, and this is the state.
No increase, but the bill totally assumes that there will be an increase. And this is why this is important. And members, I want you to pay attention to this because we just seem to be doing this because we can do it. As you know, when 0.45 roll off, we're going to have some serious fiscal issues. Now, we're going to lose what we know from 2023, $2.9 million for our present permitting program. This bill assumes individuals will increase their permitting numbers. But you know, well, think about it for yourself. If you can carry a concealed weapon, why would you get a permit? This won't be an incentive for you to do that because folk presently have the ability to get insurance to protect themselves. And they don't do it. They don't get it. They don't get the insurance. So I'm just simply saying that we need to be very careful about how we just eagerly embracing these pieces. And we say it's all about making the public safer. Thank you.
Thank you so much, Senator Bowie. And during committee, state police came to testify and with their opinion of the effects of this would be on their the fiscal impact, and they said it would have little to no fiscal impact. They were not concerned. We also had testimony that state police is collecting far above what it takes to administer this program. So that was the main reason for their lack of concern for the bill.
That was a wonderful closing, Senator Miguez. Senator Miguez moves final passage of Senate Bill 2. All those, when the clerk opens machines, all those in favor vote yes, all opposed vote no. Secretary will open machines. Vote your machines. Fields, no. Madam Secretary will close the machine. 27 yeas, 11 nays, and the bill is passed. Senator Miguez moves to reconsider the vote by which the bill passed and lay that motion on the table without objection, so ordered. Senator Miguez would like to open the bill for co-authors. Madam Secretary, please open the bill machines for co-authors. Co-authors, members. Madam Secretary will close the machine. 19 co-authors, 19 co-authors. Next bill.
Senator McMath now moves for suspension of the rules for the purposes of taking up Senate Bill 5. It's an act to amend Title 15 relative to parole, to provide relative to parole procedures, and to provide relative to the votes required for parole decisions.
Without objection. Senator McMath on your bill.
Thank you, Mr. President. Members, Senate Bill 5 is a parole reform bill. The current parole system results in the Pardon and Parole Board dockets being clogged up with repeat applications from inmates where there has been little or no change in their circumstances from their most recent denial of parole or pardon, leaving less and less time and resources to deal with the inmates who have actual legitimate potential for parole, release, or pardon. In addition, the victims and victims' families, importantly, are being forcibly dragged through this process repeatedly for no good reason. I'd like to talk about what the bill actually does. It increases the time between applications for parole for all crimes of violence and sex offenses to 5 years from the latest denial. Requires that parole board decisions be unanimous. Currently, some crimes only require a 2/3 vote or a majority if more than 3 parole board members are present. Importantly, members, I know that some of you have some concerns with the unanimous aspect of this. I pulled some stats